All right, welcome back to the committee this Thursday afternoon, May 1st. And just a preview of what we're going to be working on. We have an amendment to S87, some language that has been worked on, including with Judge Zone, and then some suggested further language from the witnesses we're going to talk a little bit about. Then we have Justice Reiber is going to be coming, I believe, zooming in at about 3:30 to talk about a little more about H-193. And then we'll have a straw poll on whether we're going to put that into the miscellaneous bill. And then we're going to have Eric go through the miscellaneous bill to try to set us up for actually voting it out tomorrow. Don't know if that's 87, if we're going to somehow wrangle that to be ready for vote tomorrow. But I do think, just for folks, and we'll change the schedule, I will put S44 down for committee discussion and possible vote. It'll be as passed the Senate. You know, I've been holding that just in case something came up today and whether the education thing, suggested any additional changes. And I don't think either of those really did. So we're going to put that on for a vote tomorrow, S44. So over to you, Michelle. And welcome back to the lovely state of Vermont.
Thank you very much.
We had a good week.
Sure.
Yeah, I was thinking the same thing.
I will just, if I
You're
could have,
nicer than I would have been.
if I'll just have a moment of personal privilege, just to let everybody know, because I could send an email or whatever, but my last day of the session, I'm not quitting or anything, but my last day of session will be May 13th. I'm leaving a little early because my partner is having heart surgery. And so I was just down in New York earlier this week is why I wasn't here, because we were meeting with the surgeon and doing some pre-op testing. So, but I did go to the opera and the Met and MoMA in between hospital appointments. So I guess I did have a nice break. But in general,
Parker was healthy.
and he's doing, he was driving it all. So,
Adjourn now May 13th if you won't be here, because we'll miss you too much.
That's a darn good idea.
and then also just to add on that, my daughter's having surgery on Monday. And so I will be here next week, but I will be remote, at least for the first half of the week until I feel like I can leave her. So
Okay.
there you go. We're all fine. You know, we're all going to be fine. Yeah. So,
There's going to be a Bryn in our near future.
it might be. I just kind of wanted to let everybody know I'm not avoiding you. There's just a lot going on. But I wanted to let you know.
Oh, it's welcome Bryn right now. Make her finish what she started.
So, all right. So extradition, I actually didn't think I would be here. I thought I was going to have to be in the Senate. So, and I haven't been here for a lot of your discussions on extradition, but I will do my best. I met with the chair and Representative Goodnott last week, Friday, I think, on just talking about where to go in the next draft. Remember, the sticking point is really on the issue of waivers. You've had a lot of testimony from various witnesses on how to approach kind of an expedited process for how to address waivers right now. Person has to sign the waiver in front of the court in order to waive their right to go back to the demanding state. There've been different proposals. I honestly don't remember which ones have seen the light of day and that you've discussed, but the one right now, if you take a look at, we're talking about section 3, starts on page 2. You'll see the existing language in subsection A, which is now A1. The new language starts on line 6 on page 3, subdivision 2, is that if the person has previously signed an authenticated waiver of extradition to the demanding state. And so remember, we're talking about this is that someone is been released on bail, or they and they have as a condition they've signed a waiver of extradition. It could be that it's part of a sentence. So they've already been adjudicated and it's a condition of their sentence. So if they have a previously signed authenticated waiver, the waiver shall be presumed valid If the person contests the validity of the previously signed waiver, the person bears the burden of proving that the waiver is not valid. So that's a presumption, and it would be up to the defendant to have to prove that it's not valid. If the court finds that the waiver is valid, it can proceed as if the person had consented to the return of the demanding state in accordance with subdivision 1. So basically that would suffice in that particular case. So I know that a lot of the discussion has been about whether or not the person needs to appear before a judicial officer, or whether or not there can be some type of other process through authentication of documents that the waiver is valid and not having to bring the person before the court. So this one would be before the court. So whenever that person makes appearance in court, if there is evidence of the waiver, then it would just be as if the person signed the waiver in court. So I understand that there's a proposal from the state's attorneys, and that's on the kind of like one pager that you have. It's not on here. And so I know the Judge Soning's, I think, on your witness list today, he did take a look at this language and was okay with this language. So I think he can talk to you about his concerns about kind of not having any court officer involved around validation of the warrant, of the extradition warrant without, if it's not in front of the court.
Okay. Any questions on that part? And I think we'll have Kim come up and kind of talk us through the additional language and where that came from and why that is, and then we'll hear from other witnesses on it. Does that work?
Sure.
And we all have a copy of the language as well.
No, we got out of email.
Yes. I've learned my lesson as far as discussing language that we don't have in front of us.
That would be really hard. Hello, everyone. Kim McManus with the Department of State's Attorneys and Sheriffs. So thank you for having us again on this. When I read the proposed language, which it needs to be noted is a nice, simple solution to what we were trying to get at as far as this presumption for these pre-signed waivers, and that should be an easy sort of off-ramp when that exists if we find that it's valid. So neat, clean, fantastic, which we like. What I did want to point out to the committee is that the way it's written and where it's fit in, it would require law enforcement and the state's attorney to file a fugitive of justice charge as per usual. And then at that initial hearing, this waiver could come up and this off-ramp, so to speak, could be taken. A number of individuals have spoken about sort of the paperwork required to do that, and sort of a frustration from some in law enforcement. I won't say all, but some in law enforcement that like this out-of-state warrant exists, this waiver exists. Like, do we really have to do everything around charging this as a fugitive from justice case? And so only with that thought in mind, if the committee would like to consider whether or not law enforcement could have a simplified process in this narrow area, I took a stab at creating language that would alleviate that need to have that charge. And that's the language before you. And it was sent with many caveats that I do not draft legislation and that it would likely need a lot of fixing, but that was the idea behind it. I think an important part of this stage of this bill is to note this piece we may or may not want to be trying to wrestle with and fix at this time. The most important part, I think, about the extradition bill is the time commitments on the front end, which I think everyone feels mostly okay about. I won't speak for you all, but that does not seem to be where we've been spending our time. So I suggest this language only because the problem's been raised on a number of occasions. And if the committee did want to look into this, this is a suggestion at this point. Happy to take any questions.
Any questions on that? Don't think any questions yet. I'm sure we'll have some once we hear from Judge Zone as well. But yeah, go ahead.
And just one question I have is with the proposed language that we're looking at for not having to charge the fugitive justice if they've got an a waiver of the extradition. Would this still have the defendant go before the judge in the same hearing that they would have gone to had they been charged with a fugitive justice charge?
That is the intent.
Okay.
Yes, so that sort of, middle of the night scenario occurs, the lodging occurs, pre-signed waiver, law enforcement sees, this subsection. Great, I can do a written statement. I need to hit these 3 points that, this person has broken the terms, blah, 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 has an extradition warrant, has a pre-signed waiver. I attach those documents. That's all I need to do when I bring person to court the next day. That was the intent around it.
Okay.
And then again, then the judge does the process above in part 2 of needing to see that this is valid. And if it wasn't valid, then the regular process would need to begin. And so then that is a question for law enforcement, whether that would be a frustration at that moment to then have to go and scurry to get that together, but I don't know the answer to that off the top of my head.
Okay. Well, let's hear from Judge Zone on the language in the draft 3.2 and the additional language, and let's see if we have some ideas that can get to the expedited law enforcement component of this. Judge Zone, thank you for being here.
My pleasure. So good afternoon, Tom Zone, Chief Superior Judge. The subsection 2 that has been added, that language reflects the fact that when you have a waiver under the current law, that waiver has to be executed before the judge under section 4967. And so what happens with this new language is it recognizes that there may be times that there's a prior waiver and you don't have to have that prior waiver. They don't have to execute a new waiver in front of the judge here in Vermont. It allows the judge to consider that and treat it as though it's a waiver that was executed before the judge. It's a policy decision, but it's one that the language there is clear as to what's intended. Will there be challenges when you have that type of new language? I would anticipate there's always going to be challenges to different things, but this happens in a process as follows. Individual is, let's say, arrested in the middle of the night. The judge gets a phone call. The judge gets an affidavit from the officer under oath saying, I'm picking this person up and we're going to try to extradite them. And here's the information. The judge reviews it, makes a decision on bail, holds the person based upon the fact that there's going to be this extradition proceeding. And when they come to court, the state's attorney files the petition with the attached documents that law enforcement has assisted them in getting. And the court then will address the individual, notify them of their rights to seek a writ of habeas corpus, the right to waive, and then the state can say, oh, judge, we have a waiver. And the court would then at that time take such steps as are necessary to address whether there was a waiver. And if the court finds that there was a waiver and the defendant has not established that has not established its invalidity under this statute, the judge has the authority to say, we are now sending you, the court's entering an order that you're going back, just as if you would waive the extradition before the court. So that's the intent. The next section that the state's attorneys have put forth today is different. That is, it would be in the middle of the night, the judge gets woken up and told, we have this person. If the judge says you're going to, or you're going to be filing for an extradition, and states, and the officer says, no, we're going to do the short form. And I'll call it short form because it's not requiring a petition, apparently. The first question that arises is, well, what authority does the court have to hold somebody?
Yeah.
Authority for issuing bail is when there's a petition for a rendition of the individual. This is not a petition. It's specifically excluded as having to file a petition. And so the first question that I think, if this new language were adopted, is whether in the middle of the night, law enforcement, if they called a judge, whether the judge could actually order bail. Courts will have to assess that legality and how to do that. I can't give an advisory opinion on that. Does it end up that law enforcement has to keep them the entire night and bring them to court? Because the next question that arises under this new proposed language is who makes the filing with the court? Well, it says that the officer does. However, officers don't make direct filings with courts under Odyssey of pleadings. So the question that then arises is, well, is the state's attorney's office involved at all? Do they have oversight in the middle of the night? Because in order to make legal determinations as to whether there's a valid waiver or a valid extraditable warrant, is that going to be simply for the law enforcement officer to make on his or her own accord? Or are they going to have to contact the state's attorney to say, is this extraditable? Is this a valid warrant? And so it's unclear there. Once you assume that, okay, maybe the law enforcement officer brings the person in, brings it in paper, and it somehow gets in, who appears at the hearing? Is the state's attorney prosecuting this? Because there's no petition that's been filed to prosecute. And so then what happens is if the court hears it, the next question that could arise is, what happens if, and we've seen this in cases where there might be a signature missing and there's something that's not there. If there's no petition that's been filed and the judge says, well, this isn't proper, then what happens? Does the individual just walk out because there's no petition and there's no order to hold them? But that also leads to another problem. This doesn't say any findings the judge has to make as to the validity of the documents. And so the statute just says that they have to allege certain things. It doesn't say the court has to find certain things with those documents. And so this raises what I would say are some overarching questions that will need to be addressed if this language were adopted. And that is, can a short form waiver filing, as is contemplated by this new language, be its own type of case for the courts to rely on in moving forward on an extradition, considering the other statutes governing extradition and an individual's constitutional due process rights? Another question that the courts will have to address if this statute were passed and was acted upon is, can a court order extradition based upon a waiver, absent of finding that there's actually a valid basis for the extradition request itself? In other words, is a petition for extradition a necessary prerequisite to a judicial order for somebody to be ordered to have to be extradited? Is the officer filing the documents in the county of arrest or the county of detention? As I've already mentioned, there's a question that arises as to the authority of the court to order someone held overnight if there's no petition and oath documents being filed. If the state's attorney is not going to be involved in the oversight, again, there are questions that I would have as to who's going to be appearing in court, who's going to be making the filings. And again, the document, this new language doesn't talk about any findings the court has to make. And the fundamental question really is, in my mind, what is the benefit that this approach brings when the law enforcement officer still has to file a number of documents, still has to get those documents together, and the only thing that's different is there's no petition with state's attorney oversight and review? In my understanding, that it's not a matter for the state's attorneys to have to recreate the wheel every time. My understanding is it's a fillable form for extradition. They get the paperwork, they can review it, file it, and come to court. And so I guess to sum up my testimony, adding this language brings with it a number of questions that courts will be addressing and wrestling with and ruling upon. Simply sticking with subsection 2 does not give rise to the same amount and depth of questions. Let's put it that way.
All right, Tom. Hey, Judge. My suggestion, I think we spoke briefly, but afterwards I was speaking with the state's attorneys and stuff like that was, when I say form or short form, it's basically an affidavit, a signed affidavit from a law enforcement officer, including the information that you would normally get in a full-blown affidavit, along with a printout of everything from the demanding state that would normally be attached to the same said case, including the waiver, the previous waiver from their state, or yeah. So
that brings with it the concerns I raised about holding someone overnight, who prosecutes the case. Can you have an extradition waiver without an actual extradition petition? These are questions the court would have to address under that.
Well, that's what the form would be, an extradition petition, but it would be a form as opposed to having to type out a 3-4 page affidavit. It is a warrant. It's just not from our state. Correction, if there's somebody post adjudication, corrections will take and run with that without judicial review and send them right back. Where, I'm not even sure we can find out without contacting the demanding state what type of warrant it really is. Is it a probationary warrant, or are they just wanted for whatever crime? Have they been sentenced for it? Is it pre-adjudication, post-adjudication, after sentence or not? So I wonder if it's gonna run afoul on either side of this, to be perfectly honest. I'm just thinking simplifying the affidavit process, but it's still an affidavit. It's just a form versus a typed out one. You just fill in the blanks,
I'm unaware of anything that says that law enforcement can't have, just like the state's attorneys have for I'm sure for their petitions, when they have fillable forms.
Yeah.
I'm sure law enforcement can develop fillable forms that contain all the relevant information and attach them.
Right. I'm just hoping that that's enough to fulfill what you would need for, what you would, to have an information in court, I guess. We don't
It's
use the
not-
same form as the state's attorney.
It's not a petition. And that's what I'm trying to explain, I guess, is that there's a difference between a petition for rendition for someone to be extradited and some kind of officer's affidavit short form. If the legislature decides as a matter of policy that it wants to go down an officer short form, the questions that I identified initially are the questions which will arise in the cases. If you decide to go down there, again, that's a policy. It's just like when S-87 came over. S-87 came over from the Senate with no judicial involvement. If the legislature wants to have that policy of no judicial involvement and defer to the executive branch to make those decisions to extradite people with no court proceeding, based upon the law enforcement officer's evaluation of the paperwork as being valid and okay, that's a legislative policy. That would not involve the courts, unless, of course, someone gets sent back to California when they shouldn't have been, and then maybe they'll come to say, well, what's going on now? So that, those are the types of issues that can arise.
Right. Well, but even in the corrections post-adjudication situation, it's still, we're running off the same information that we receive from the other state and relying upon that 100%. And I'm going to do everything plus probably some more than corrections normally would do.
If you're referring to the corrections individuals who are here under the compacts for supervision, that is a different circumstance because they have agreed to certain terms and conditions in order to be in Vermont. Extradition is someone who comes to Vermont. They by definition, they don't have permission to have been away from the state they're in, or they're fleeing the prosecution. Those are the cases that are covered by the extradition statutes. The cases with the Department of Corrections are different because when those individuals come here, they know what's going to happen. They know they don't get a court hearing. They know that they're going to be held and they're going to be sent back. And there's no judicial intervention because different statutory framework.
Right. That's sort of like what they're being told in the state they just came from if they signed a waiver.
They're being told that if you sign a waiver, you're waiving your right to extradition. I don't know that they're being told that you're waiving your right to judicial review and having an extradition petition filed.
Okay.
So Rebecca, do you want to weigh in on this? Are there more questions for Judge Zone at this point? Well, I can see you have a question. Ian.
I don't really have a question. I guess my question would be, let's not talk about the new language, the language that's not in the proposed draft 3.2. Do you think that if we're just looking at draft 3.2, are we providing state's attorneys with an opportunity to off-ramp extradition processes where there's a waiver in a more expedient way than currently exists in law?
Yes, if right now the statute requires that it be signed in front of the court. There are some,
and they don't have to. They don't have to sign it.
They know this provides the state's attorney a basis to say, Judge, the legislature has a policy. If someone's waived it ahead of time, that counts the same as a waiver in court. We're asking you to enforce it. And so it absolutely provides a mechanism that could speed up the process and have someone extradited without the need of obtaining the governor's warrant.
And I think my only other question is, as I come to the defense of the state's attorney's language, would it change your testimony at all if the intent here was to plug this language in right before the adjudication of the waiver? So basically, this language that's proposed would be another way to get the defendant in front of the judge, and the judge would then make the same assessment as is proposed in section 2. A2. Do you see what I'm saying?
I do, and it would not change my testimony.
Okay.
The concerns that I've raised about the potential challenges and impacts and the determinations the court would have to make remain the same, no matter where you put it.
So is it a matter in part of how much law enforcement in their practices already put into an affidavit? And I'm just kind of curious if there should be a review of whether all the information is necessary that's being put into affidavits supporting petitions for extradition. Now, I'm not. Yeah, go ahead.
That's something the state's attorneys, as chief law enforcement officers of the county, should be visiting with law enforcement on, saying, here's what we need from you. Here's what the court has to find. Here's what we'd like your affidavits to contain. So that is absolutely something that's a discussion worth having between. If law enforcement says, we think we're giving you too much, it should be the state's attorneys who tell them what they need to file a petition that's going to meet the statutory requirements.
So if we were to put in a request, or I guess a demand for the Department of State's attorneys, Defender General, and law enforcement, somebody in law enforcement to review that, I'll get the other witnesses' view. Would that be something that the court would not want to be involved in because it might be coming before the court, or would that be something like a working group task force? We'll have to figure out which of the, or is that not That's getting too much into their business.
I think it's too much into their business. The job of the court is to see what's there for the information that's brought before us. By our orders, we can set forth what is required by the law, and the parties bring it to us. I would be remiss if I didn't note that we're having this discussion about trying to shorten things, and it sounds to me like all that's being shortened is we're taking out the step of the state's attorney plugging in the information and filing the petition. And I don't know how much that really shortens when you look at all the potential issues that arise when you take that petition out.
Right. Understood. Anything else from Judge Zoe? Not seeing any. Let's go first, Rebecca, or Kim, do you want to come back and respond to my, whether we need to ask you to do something as opposed to you all do it on your own? Rebecca, if you could join us, and I think, yeah, well,
Can I just have one thing?
yeah.
Do you agree with that or not? I mean,
Agree with what?
what the judge just said, it's just taking you out of it, right?
Well, the intent was to also lessen the work on law enforcement side. What we've heard throughout the testimony for filing the punitive justice charge, that it's more elaborate than what was suggested here, a simpler version. But again, this was only a suggestion to.
So are you okay with it? So are you okay with it or you don't? Too early.
Okay with what?
Are you okay with what's being proposed?
I don't know what's being proposed.
What did-
Judge Sonny's, I mean, essentially saying, take that language out. And as I testified earlier, we're perfectly happy with section 2. And it was just a suggestion if we wanted to talk further about the other issue, the other language. But if the language is taken out, we have no issue.
Okay, I probably got sidetracked.
Thank you.
As I said, that's my favorite.
Rebecca, why don't you come and join us, and so we're really looking at just the language in this draft number 3.2, if you have any further comments on it.
Our office got this draft maybe a half an hour ago. So we did not get the courtesy of any advance notice. So I am winging it based on what I've just heard.
Okay.
So we have asked multiple times this morning for some notice. So if our opinion is desired on this in advance to be useful for a hearing, I would request that I know that the nature of this is very short turnaround request, but it sounds like some of the witnesses had some more notice than I am. But I will, listening to Judge Zone, I too wondered how the state's attorneys responded to what I heard and understood Judge Zone's concerns to be beyond just this proposal of this draft from the state's attorney, which I now understand you are agreeing not to pull off the table. I won't consider that. But this is, again, I'm not quite sure where if I
focus on the language that is in draft number 3.2.
Just basically.
On page 3, lines 6 to 11 is the new language. We got rid of most everything else that had been up there, So
I understand that Judge Zone, again, trying to catch up. That he also expressed concerns about the constitutionality of it. I think he said it was less breadth and depth, perhaps, of the constitutional concerns, but that it didn't fly. I'm going to share what ours are. I understand that the intent is to somehow find a place for these out-of-state waivers, right? A place for the court to consider to perhaps make that an efficient part of the process. If it was previously waived, right to extradition, then I understand that is really at the heart of trying to streamline, right? Now, if that's the case, it could be just that it may be considered, right? Maybe you can just add a line in the statute that just says these out-of-state waivers may be considered as relevant. But the concerns that Judge Zone raised on this part 2, which certainly defense attorneys, if we had a role, if I understand it right, this would not change the current process, which would there be an arraignment, the person will be brought before the court, and so the person would get an attorney. Right? I understand that is not changing with this. But that if there is a waiver presented and if authenticated, it's presumed valid. So some of the questions that I heard Judge Zone raised last week, what is the meaning of valid? What's a valid waiver, right? As came up today, a waiver signed in another state may not have been done with the knowledge that they were waiving even the process or going before the asylum states. It's like, what was the extent of the waiver? Is a waiver in another state an apple, an apple, an apple, right? And I think the point is there are so many different waivers. It's as designed by the outside state. And so to have this sort of generic language have such sweeping effect of bypassing rights is too simplistic. And that's where there's a real concern as to bypassing key constitutional due process.
Yes. So I have a couple questions, but first, like, we're not bypassing rights. We're talking about whether right was waived, correct?
Correct. But
and then the other question I have is just, is it I understand the broad, this, what's a valid waiver? Aren't those questions that you've raised about, what was said in the other state? Was it made knowingly?
Right.
Are those not things that a defense attorney could just bring as a challenge to the validity of the waiver? And if they put a compelling argument before the judge could say, you know what, you're right, this isn't valid. And now they just go through the rest of the extradition process, and we protected the constitutional rights of an individual through the process we're proposing.
that is all well and sounds good, except what is the definition of valid? What is a valid waiver? This is the point of where you're opening up all these undefined terms and where it has constitutional meaning, right?
So I don't think that Judge Zone had concerns with the language in here. And I also want to just back up and give a bigger picture. The reason this language is in here is because of the Defender General's office's pushback on as passed the Senate, which apparently they didn't raise those concerns before the Senate Judiciary Committee. So I'm happy to put this away and go back to as passed the Senate. We've been trying to accommodate the concerns that you've been bringing here, and I think these do that. And I think Judge Zone has said okay to that. So, I mean, given that, I want to understand you're attacking this, which, we're not going far enough. I think the court can understand what valid means. They're allowed to rebut the presumption. So I think that's, I'm just kind of at a little bit of loss.
Well, again, courtesy of not reading this language in real time, and I'm trying to respond. To address the issue of not having this raised earlier, I wasn't there in Senate Judiciary. I had a colleague go in. And as is the case of how these things develop, the concerns weren't raised or identified there. I came in, had I been there, I would have raised them earlier. It's not something that we held back to raise. We're sharing this. We're imperfect as well, but it's better to have these concerns voiced now that you know that what you can expect if this passes from the defense perspective, some very considerable concerns of bypassing some rights. Just because someone may have signed a waiver in another state of extradition, and to what extent, under what was waived, right? Was it knowing and intelligently done? All of this will be questioned at the arraignment. Again, back to the question. Then here's the other part. Let me back up. Not just about the validity of the waiver itself. I understood Judge Zone, and again, jumping in here, if you don't have a valid petition of rendition filed, consistent with supporting a otherwise warrantless seizure of a person who's being held, what is the authority of a court to continue to hold somebody? Right. And so, again, I'm not understanding quite how this, let's assume an out-of-state waiver is deemed valid. How can a court, consistent with both due process, Fourth Amendment, and Article 11, justify seizure detention of someone while they're waiting for the demanding state to arrive, and then holding and releasing this person, again, if it's outside of the extradition process, which is about the initial petition of rendition being sufficiently supported by probable cause. Now, if maybe you can clarify, does this process bypass the petition for rendition that's normally supplied? My understanding is it is somehow being proposed to bypass it.
This was the additional language, but that the language in 3.2 does not bypass that.
So you would have the traditional way, so we would have nothing changed on that front.
That's my understanding.
Short form law enforcement only filing.
Well, that's the other language that we're not talking about.
So that is out there, like if this and this, so, right. No, I mean, so then we're back into more familiar extradition proceedings, right? And so if the judge were to find probable cause with that petition to justify the proceedings, then perhaps you're in then that territory, the statutory scheme of bail. But then if this is found valid, you would go right to skipping that, if I understand this right, and going right to transport.
If the waiver and defendant has the opportunity to rebut the presumption that the waiver is valid by showing that it wasn't knowing or whatever the evidence he or she would probably bring forward. Otherwise, then it is treated just as if it's under the previous subsection, subdivision A1. I mean, it frankly doesn't do a huge amount. I mean, it's like they can come in there and they can waive that day, or they can say, yeah, I did that previous waiver. Yeah, that's fine. Or they contest that previous waiver and they have the hearing about whether that previous waiver was valid or not
And I think that I'm curious, wouldn't all of your points about if the waiver is found to be valid, wouldn't all those points apply also to a defendant who waives the day of? So they're going to go be held and get transported, and they're going to they're waiving the extradition right, which they have the right to do, right? So it's just basically this very narrow question of like, are we going to treat a pre-signed waiver like we would treat a waiver the day of? And
Yes.
We're giving a defendant the opportunity to challenge that pre-signed waiver in a judicial setting with a judge and attorney, if for some reason the validity is in question. So I'm just curious, like what are we proposing here that gets us like way outside of what's already happening as far as protecting defendants' rights and making sure that we have a valid constitutional process?
First, waiver in Vermont, present waiver before a Vermont judge, and after a judge has found probable cause to support the petition rendition, is wholly different than a waiver signed years ago in a different context, in a different state with different standards, right? So that's apples and oranges, just to compare. So one waiver signed, how many years old, right? 20 years ago, cannot stand for the same present of, do you know you're aware of you have a right to XYZ in these current, present, fugitive extradition proceedings? Do you understand? And if you waive, right? Do you understand you have a right to habeas? How do we know? All of that was explained at the time, 20 years ago, 30 years ago, 1 year ago in Arkansas and California. Is this waiver signed in the context of a pre-trial condition of release, or is it a post-conviction sentencing probation? States that have allowed these waivers, right, as valid to constitute a waiver of extradition in the asylum state have limited them to the post-conviction sentencing realm. I know that this committee started there. This language, if I'm reading this right, opens that back up so that waivers done pre-trial are also valid. So I don't know if you realize that has sort of gone that way. But again, to say that one is the same as the other is absolutely not true. And that's the extra protection of having an in-person waiver before a Vermont judge, because we don't know. And the way that this captures, it captures all waivers signed at all times under any condition, right? And so that's the huge difference. Now, I understand that there is an interest in this. I'm just sharing that even 24 hours, I could have had a little bit more time to prep. And that's how much I have, that's what I have to share right now. I'm happy to come back if you have a different version.
Yeah, if anything changes, you're welcome. If you need more time, if you're gonna say something different, we'll have you in after the floor tomorrow morning. So we do have it scheduled for a vote in the afternoon, but to give you another opportunity, if you need to reach out and stuff, definitely let you do that. So if Tom, did you want to speak to this?
I had it very brief, I think. Good afternoon.
Afternoon. Yeah.
Delos, Assistant Attorney General. Good to see you all. On a policy matter, we continue to support the version passed by the Senate because of the simplicity and straightforward nature of it. We understand what this new version, which also for the record, I learned about as I sat down in this room. So I think everybody's sort of in the same state of reacting to it. And I would say it would seem to satisfy the concerns I've heard from this committee. And we wouldn't object to where it sits right now. I think the only other point I would make is a small request for an edit to it, which is just in the original version in S87 as it passed the Senate, we had that line, reliable electronic means. It basically allows us not to wait on the physical copies of things to come from physical courtrooms in other states. I don't know. I would defer to Judge Zone on what the court would accept as meaningful evidence, but I wouldn't want to run into an authenticity problem that would then require someone being held for longer or otherwise clogging up the courts and state's attorneys, et cetera, for longer.
But you have no idea why that line disappeared then?
I don't know directly. I imagine because of the previous draft, which was less clear. And I say that as the author of, largely the author of the previous draft. I think it probably was struck as the redrafting. I don't know of an intent to strike it, but
No, there wasn't an intent.
That's what
Yeah, there wasn't an intent. That was just in the drafting.
oversight.
that was my assumption.
And if you could touch base with Michelle to tell her where that goes back in. 'Cause-
Happy to do that.
Yeah, Tom.
Do we have a state where this is being used as an example? So I can look up, I want to actually pull a warrant and see.
Yeah, so I spoke to folks at DOC this afternoon on a high level about sort of what works and what doesn't. And I think there's something like, I had been saying 14 and the number became higher than that when I talked to DOC. I don't want to speak to it. I can get you from Morgan Rogers at DOC. I will connect the two of you. Yeah.
I can just try to look up.
Yeah.
See what it actually lists in the system for evidence.
Have Kim again, just for a moment. Gotta kill 15 minutes, before Justice Ryder.
You get a break.
Like, no, this will be very short. Yeah, no, this is very short. I mean, does it make sense that the Department of State's attorneys would work with law enforcement to look at what these petitions are including to see if there's a way to streamline it in a manner that is actually lawful, that we don't have to try to legislate?
Yeah, I think it's raised a really interesting conversation about, because I have to admit, I went back into the extradition statutes because I was trying to find, what else has to be in here, like what's causing all the paperwork. And so I don't know how much is sort of practice over time.
Right.
It's that sort of, as we all know, like, oh, but this is how we do it. And it's like, well, why?
That's what we've always done.
That's how we've always done it. So I think it's a wonderful opportunity for us to review with law enforcement what's needed and if there's a way to, and if it can be simplified, not to not meet the standard, but just to lessen the paperwork side, if there's opportunity there. I think this is a wonderful conversation for us to have to go back and see and maybe address some of the issues that were raised without having to look at anything I've written.
Okay, so would the letter from the Judiciary Committee help that process? Just to kind of,
I think when we do our training in June and we talk about the S87, which hopefully moves forward, I think that's the perfect opportunity for me to express what came up and how we all tried to wrap our hands around it. And then is there a way we can, on our own, with law enforcement, find a solution? Yes. And so I don't think we need a letter, but if you send one, I'll be happy to share.
Would it hurt?
All right, well, thank you very much. And we'll take a 10-minute break and we do have Justice Reiber
Thank you.
who's going to be here via Zoom at 3:30. So please don't let the chief